in Panagar, the accident rather, so where a lady passenger died. We had carried a news article on this. First of all, the P1, he's neither the news anchor, not even he's involved in this reporting. They say, kindly look at the FIR, the complaint. Again, the police is the complainant. At page 73 and 75. Complaint. Now, under 353, 1. I don't know how the kindly look at. Okay. No element, nothing made out with regard to how 353 1 is being
what is there in this case? Ki jhamela arambo koreche.
But I tell you,
There's nothing.
thing is,
What
is being circulated is contrary to what has happened. I'll tell you, Lordship, what has happened is, now, my lord, this victim, she is an event manager. Now, the event manager was going from Kolkata to Bodh Gaya by a Tata Tiago car. One of her other team, they were traveling by train. So the entire team was traveling in two groups. One by a Tata Tiago car, the other by a train. Now, the Tata Tiago car, had gone to a petrol pump and from there filled the oil tank, and they were proceeding towards the Panagar side. Finally, they'll go to Bodh Gaya. Now, what happens is, there was a Creta car, the owner of which is a scrap dealer. The scrap dealer has a business somewhere in Panagar. This scrap dealer's, one of the employees' son had consumed poison and had committed suicide. Now, he was the person who had committed suicide was brought at a hospital in Burdwan. Now, the Creta car owner, with two or three of his employees, comes to the hospital to see, and then they were going back towards Panagar with the apprehension that either the wife of the person who has committed suicide or his mother, they are also likely to consume poison because of what has happened. Therefore, my lord, the Creta car was in a high speed. No dispute on that. Therefore, the Creta car, first overtook, the Tiago car. Now, when the Tiago car, overtook him, this is a silly thing, my lord. Then the victim, she receives a telephone call from the other group that there was some altercation between a hotel owner and one of the group members over French fry, aloo bhaja. How silly things can be. And the hotel owner drove them out of the hotel, the group which was traveling in train. This dispute was communicated to the victim because she happens to be the main person. She got irritated on that news. Then, my lord, she asked that go chase this car. Now, they were chasing the car. The Creta, first they overtook. Then the Creta again overtook the car, Tiago car.
But the Creta has something to do with the hotel.
No, nothing to do. They don't know each other. This is not at all a case of eve teasing. Now, these have all come out during investigation. Initially, my lord, the passengers of the Tata Tiago car had said that it was, though there is nothing in the complaint, in the statements they had said that it was a case of eve teasing. Later on, they had retracted from them. 164 statements are there. Now, when for the last time, the Creta car overtook the Tiago, then, my lord, the bumper, the backside bumper of the Creta car touched the front side, left-hand side bumper of the Tiago car. Now, to this, my lord, this lady, the victim, got emotionally infuriated, if I may use this word, because this was her father's car who had expired 8 months back. Therefore, she said that go and catch this car. Now, this went on that the Tiago was chasing the this Creta to catch them, and by that, for about 15 or odd kilometers, this chasing took place, and then the Creta car had come to its destination. They were supposed to enter into a lane in Panagar, where their destination point. Now, since he was chasing, the Tiago was chasing, the Tiago came and hit the this Creta, and thereafter, since it was in a very high speed, it dashed the Creta car and there was an urinal over there, and then it dashed against the urinal, and the car, Millard, toppled. And this is what has happened. Now, thereafter, Millard, the case of eve teasing was being circulated. We have CCTV footages of almost 70 to 75% of this chasing, who chased whom, who chased not, etc. Not the entire thing, as I am instructed. Then, Millard, the commissioner himself looked into the CCTV footages and could ascertain that this was not a case that one knew the other, or there were some lewd comments, or there was some eve teasing. Then, Millard, the commissioner briefed the press at 6:45 p.m., in which one of them was the present, Millard, company, or Millard, the media house, that no, this was not a case of eve teasing, etc. So this is what has happened. This was briefed. Even thereafter, till the next day morning, Millard, this media house kept on telecasting that this was a case of eve teasing. The Creta car was chasing the other car, etc., etc. Now, this is the subject matter before my lord. Now, my lord, please have a look to my lord. What is the FIR? Now, FIR and what has been collected during investigation is much, much more than the FIR. But this is not a case, my lord. The first thing is, on the, my lord, aspect of the role of media, your lordships have held that they should not disseminate inaccurate news. The time has come for your lordships to lay down the guidelines. Every day we find in the news media the same story is being telecast by all, and everybody claims to be it's exclusive. Number one. And number two, they say that we have come across a video footage, or we have come across a telephone conversation. We have not checked the accuracy of that, but we are presenting it before you. That is not the role of the media. Unless you check the accuracy, you're not supposed to disseminate those information. Because the media house, just digressing for a moment from this case, because the media house is, my lord, collecting information for me. In my very humble submission, it is a wrong concept that the media is exercising its rights of speech and expression. It is the media house or the news agency, they collect the information for me and they present it to the public at large. Therefore, I have a right to be informed of the correct news. This is one part, not very important at this stage. The important part is that here, my lord, after the police commissioner, my lord, informs in the news media that no, this was not a case of eve teasing. I have gone through the CCTV footages. This has happened, that has happened. But I can understand that that was a public perception. A media house, based on public perception, my lord, had covered a news telecast. But once the investigating agency comes and says that what you are disseminating is incorrect, and even if thereafter, unless my learned friend says that after the CP had made the press briefing, they had withdrawn whatever they had said, then it's a different thing. They should come up with a supplementary affidavit, since I'm making this submission before the court, to this effect. Otherwise, my lord, this, in my very respectful submission, my lord, attracts, my lord, the provisions of 353 1B and 2. Now, if you compare, my lord, 353, kindly see, my lord, in the previous law, the expression wrong information was not there. Oh, the penal code, check. 353. এটা তো বিএনএসএস বিএনএস কোথায় এই না এটা এটা না এখান থেকে কোথায় গেল ভাই হ্যাঁ yes well the lordship has but 353 kindly considers whoever makes, publishes, or circulates any statement, false information, rumor or report. We're pausing here for a moment. The previous law did not have the expression false information. Including through electronic means, we are concerned about B, with intent to cause or likely to cause fear or alarm to the public or to any section of the public, whereby any person may be induced to commit an offense against the state or against the public tranquility. Now, my lord, in the context of, my lord, section, but kindly considers, my lord, this with 505 of IPC. Joseph, kindly similar, 505 started with whoever makes, publishes, or circulates any statement, report, or rumor or report. Now, if your lordship kindly comes back to my lord, section 353.
Yes.
Now, please take note subsection 2. These are the two sections which are attracted. Whoever makes, publishes, or circulates any statement or report containing false information, rumor or so and so, including through electronic means, with intent to create or promote, or which is likely to create, or promote on grounds of religion, race, place of birth, residence, language, caste, or community, or any other ground whatsoever, feelings of enmity, hatred, or ill will between different religious, racial, language, or regional groups, or castes, or community shall be punished with, etc. Now, my lord, this expression likely, my lord, in the context of, my lord, section 299 of IPC, my lord, there are a host of Supreme Court judgments which says that likely means probable, not possible. Anything, my lord, which may have a probability, it may not happen. But in the other case where I used an expression remoteness. So when, my lord, the legislature uses the expression likely, it does not contemplate possibility, because an argument can be made, okay, I have disseminated a false information or a wrong information. This information does not have any possibility to do this and that.
Yes.
But there are judgments where I have those, my lord, if required, I'll give. This is number one. But this is, my lord, the situation on the day or at the time when the FIR was lodged. Now, what has happened thereafter? Applications I have received from local people that allow us to organize processions regarding Bengalis and non-Bengalis. This, my lord, we have stopped because Ucha Madhyamik examination have started, therefore we have stopped. Therefore, my lord, one is, my lord, at the stage when the FIR is lodged, it is a presumption of law, whether the ingredients are satisfied or not. The other is the aftermath of whatever, my lord, information has been disseminated. Therefore, my lord, my first respectful submission is
This has been done against how many channels? The news were uniform on those days.
yes. We have done it against one. It is not that we will spare the others. And the fact that, well, I put it, my lord, also, my lord, in a somewhat, my lord, unfair manner. The fact that I have not done it against anyone else does not, my lord, absolve them of the offences if the ingredients are satisfied. Because my first submission would be,
That is one thing, sir. But then this is reflecting another picture. You are a state.
yes.
You
Now, today, my lord, the situation is,
if there is an offender, can you pick and choose an offender? You tell me. Is the responsibility of this channel alone, which has, let me presume, there has been a disharmony for the time being without accepting anything, their contentions, whatever. is this particular is a TV channel? So, okay, is this TV channel alone responsible for this disharmony?
But as of now, Millard, it is against one. Now, Millard, the stage is, Millard, we have given Millard a 35 screen notice to them. Now, if Millard, everything is stalled Millard at the 35 stage, then Millard, these informations will be gone.
So you add everybody. This news channel you come up. This news was not. See what happens in news. What happens? Maybe a single unit is over there. They pass the information to the TV channel. All the TV channels are broadcasting or whatever they are telecasting rather. Telecasting the news. The same news is telecast in 6 or 7 channel. Now one channel, if a criminal case is registered, will not that show that the state is spiteful against a particular
Yes.
channel concerned?
But then again, Millard, please consider this point, Millard. If they allege malafide, they have to allege malafide against an individual. Millard, this expression, Millard, the Bhajan Lal's principle, but in my very respectful submission, has been wrongly applied everywhere. If it is said that the process has been initiated or the ball has been set in motion out of vengeance, out of malafide, it has to identify a person, make him a party, plead and prove. Innumerable decisions, Millard, Supreme Court has said that even in 2024, that in a case where somebody
Is it the law that it is a prerogative of the state whom to make an accused and whom not to make an
no,
accused?
but that is, Millard, subject of investigation. But your lordships have found, Millard, number one, so many situations. Number one, FIR against unknown person. Investigation started. Thereafter,
No,
Millard,
I am not on that. This is a news. This is a case of 25th of February or what? কবে হয়েছে?
This is of
25th of February.
25th. Yes.
তো
25th.
the case has been
The case
registered.
is 25th.
So there were no other channels who transmitted this news. I'm not on that, sir.
No.
If you say that this is an offense, then you must as a state, because as a state.
From this investigation also, Millard, others can be roped in.
No, but then this is why I am on, sir. Then you make others parties accused persons also. I have got nothing to say.
But let me
We'll
come
test the.
yes, definitely.
test the,
Definitely. No dispute on that. No dispute on that. Right? It's not that the person who have initiated is have any axe to grind against this channel. Whoever has done it,
Whoever has done the complaint has only made complaint against this particular channel.
yes, well, the complaint is at page.
When the news was
This is a suo moto complaint, which is at page, Millard, page number.
a police
75.
officer has done that. 75, I
Yes,
believe.
75.
I've got the issue, sir. I will test 353 1B in the strictest of terms, 353. But then the classification of the news which was transmitted
Right.
at the same time in different channels concerned.
But that can be done
That-
from this investigation
So
itself.
you add and come back.
Yes.
You add and come back. Just don't take steps.
No, that. There is no hurry. No.
You on all the channels which were available at that particular time. From that time, then we'll test 353 1B, where because the responsibility is on the society.
But kindly permit me to, Millard, investigate the other part in the sense, like, Millard, the driver.
I'm not stopping you anything. I'm not stopping you. You just, so far as the petitioners before this.
Well, for the present, Millard, may I say this, Millard, this arrangement can be made, which your lordship was pleased to make in the other one. So far as the petitioner number 1 is concerned,
Mr. There will be, you are a state, sir. You are a guardian of the citizens.
Yes.
concerned.
Yes.
There are at least 10, 15 channels, whatever it is, number, I don't know and I cannot say also. You check whether the same news was transmitted throughout
I get you, I get
and
I
make all of them an accused come before this court. Till then, don't disturb anybody.
yes, your lordship need not pass in your, I'll come back.
No,
After,
I
sir.
will not type.
No, 35 3 Millard, they were supposed to come, respond to it yesterday. We have not done it.
You carry on with the investigation. And if you require this person, you take leave of this court. I'm keeping this matter in the list. The day you say, I will take up the matter. You show me the documents that these are the number of channels here.
Page 64, earlier order, where Malad said that.
No, I'm saying
further notices.
matter will be there in the list under the heading for orders. It will continue in the list. He will come up with whatever he has committed. If he requires you, he will take permission from me and thereafter.
Very.
Up to this, it is all right. Nothing.
No.
Because if you have to settle the law must be settled for
Yes,
all the
yes.
channels concerned.
Right.
The FIR.
In fact, Millard, I had the occasion to argue one matter before another coordinate bench where, Millard, the parameters have been laid down. Though, Millard, in the context, not in the context of the criminal law, but what are the Millard parameters in regard to pending investigation. That is again a subject matter of another investigation. This is being disseminated, which Millard has a toll on the other investigation also. Can have, may not have also.
I don't think. I'm not. This particular case is exclusively under 353 1B, and this has got nothing to do with the other cases which are being investigated, and nothing is before me so far as the other cases,
Right.
except the backgrounds which have been in the form of media. Acha, Mr. Banerjee and Mr. Ganguly, learned senior advocates, appear on behalf of the petitioners, advancing their contentions regarding the applicability of the sections in respect of the news which was telecast, as has been referred to in the letter of complaint, in respect of the regarding the applicability of the sections
in respect of the news was telecast as it's been referred to letter of complaint.
She's a genesis of what is this case number? Kaksa PS case.
This is
Kaksha Police Station case number 53 of 2025. Full stop. Without going, learned advocate general intends to learned advocate general submits supports the registration of the FIR and contains that there has been certain advancement in the investigation. Full stop. It is the state's contention is that the substance of the accusations do suffice is the ingredients of the sections for which the investigation has commenced after registration of the FIR. Full stop. This court confronted the state on the issue as to whether the present channel is petition number 1 is a channel.
No, petitioners.
channel is not the accused.
Petitioner 1 had nothing to do with this. Everyone, my lord,
as to whether the petitioners being employee of a particular Bengali news channel was responsible for telecasting such information, or whether there were other TV channels which